Washington, D.C. has one of the most tenant-protective lease termination frameworks in the entire country. If you own rental property in the district, you're operating under rules that severely limit when and how you can end a tenancy. And misstepping on the process can cost you dearly. The governing law is the D.C. Rental Housing Act and the D.C. Code Title 42, Chapter 35, which includes the district's eviction and termination provisions. D.C. also has strong rent stabilization laws that directly impact a landlord's ability to terminate, making it one of the most complex jurisdictions for landlords anywhere in the United States. Let's start with the most important thing. D.C. is a just cause eviction jurisdiction. This means that landlords cannot terminate a tenancy simply because they feel like it or because the lease has expired. You must have a specific, legally recognized reason to end the tenancy. The recognized grounds include non-payment of rent, violation of a lease obligation, the tenant's use of the property for illegal purposes, the landlord's intent to personally occupy the unit, the landlord's intent to renovate or demolish the building, and discontinuation of the property's use as rental housing. Outside of these grounds, you generally cannot force a tenant to leave. For non-payment of rent, D.C. requires the landlord to provide a 30-day notice to quit before filing an eviction action. That's significantly longer than most states, where non-payment notices typically range from 3 to 14 days. The tenant has the right to pay the full amount owed during that 30-day period and remain in the unit. And even after the notice expires, the landlord must file in court. D.C. does not allow any form of self-help eviction. For lease violations other than non-payment, the landlord must provide a 30-day notice to cure or vacate. The notice must identify the specific violation and give the tenant 30 days to correct the problem. If the tenant cures the violation within the 30-day window, the termination notice is void and the tenancy continues. If the tenant fails to cure, the landlord can proceed with filing an eviction action in landlord and tenant court. For repeated lease violations, meaning the tenant has violated the same provision more than once, the landlord may be able to proceed with termination without offering another opportunity to cure. But the landlord must demonstrate the pattern of violations, and courts scrutinize these claims carefully. If the landlord wants to terminate in order to personally occupy the unit, known as an owner move-in eviction, the process is heavily regulated. The landlord must provide at least 90 days written notice. The landlord must actually intend to use the unit as their primary residence, and they must occupy it for at least 12 consecutive months after the tenant vacates. If the landlord fails to move in or doesn't stay for the required period, the displaced tenant may have grounds to sue for damages. D.C. courts take these requirements seriously, and landlords who use owner move-in as a pretext to remove tenants face significant legal exposure. For termination based on renovation or demolition, the requirements are even more stringent. The landlord must obtain all necessary permits before serving notice. The tenant is entitled to the right of first refusal to return to the unit after renovations are complete, and the landlord must provide relocation assistance to the displaced tenant, including payment of moving expenses and, in some cases, a substantial relocation fee. The specific amount of relocation assistance depends on the circumstances, but it can be significant. D.C.'s rent stabilization program adds another layer of complexity. Most rental units in the district are covered by rent control, and tenants in rent-controlled units have additional protections against termination. Landlords of rent-controlled units must register with the Rental Accommodations Division and comply with specific procedures for any termination action. For month-to-month tenancies, D.C. still requires just cause for termination. Simply providing 30 days' notice is not sufficient. You must have a legally recognized ground. This is a fundamental difference from most states, where month-to-month tenancies can typically be terminated by either party, with proper notice and without stating a reason. On the tenant side, D.C. provides several grounds for early lease termination. Tenants who are victims of an intrafamily offense, DC's term for domestic violence, can terminate their lease early by providing written notice and documentation, such as a protective order or police report. The tenant must provide at least 30 days' notice, and the landlord cannot charge an early termination penalty. Tenants can also terminate if the landlord fails to maintain the property in habitable condition. As we covered in our DC habitability video, the district has aggressive enforcement mechanisms, including the right to withhold rent, seek rent escrow, and terminate the lease when conditions are seriously deficient. Active duty military members are protected by the Federal Service Members Civil Relief Act, which allows early termination with 30 days' notice following deployment or permanent change of station orders. DC strictly prohibits self-help evictions. Landlords cannot change locks, shut off utilities, remove belongings, or take any action to force a tenant out without going through the court process. Violations can result in criminal charges, civil liability, and treble damages awarded to the tenant. DC courts take illegal lockouts extremely seriously, and landlords who attempt them face some of the harshest penalties in the nation. The eviction process in DC goes through the landlord and tenant branch of the Superior Court. The process can be lengthy. From initial filing to actual removal, cases can take several months, and sometimes longer if the tenant contests the action or asserts defenses. Landlords should be prepared for a process that requires patience, proper documentation, and experienced legal counsel. For the complete guide to Washington, D.C. lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel so you stay protected in every jurisdiction.